sounds working so quick. Pause. Yeah, we'll pause this. I can't either. So let me make sure the angle on the video is good. Okay, I mean, are you sure you don't want to point it at the screen?
Not picking up.
Yeah.
Yeah.
Is it? No. It looks really hard.
I know, I found it wrong.
Oh,
Like, I don't see, oh, I think it is working. Hello?
try plugging it into your computer instead of the HDMI port. Oh, no, it just might.
Probably.
Yeah, so we will have to do this. Okay, it's on snowball now, so it should. It was. Sure. Can I talk into it real quick?
It's working.
It says that the input is.
Hello?
Yes,
It's delayed.
it is delayed.
So how do we turn that off? No, I don't think it's been delayed in the past.
No, it has.
That's a long delay.
And I'm not gonna be able to speak and like hear myself, right?
You should be able to speak just in the laptop.
But they
Well,
won't.
it won't go back for you. It'll be delayed for the people on the other side. You won't hear it because like that was a test. So the other people, it may be a little bit delayed. You want me to-
It's asking me to sign in, but I'll just read it.
shouldn't it?
It won't do that during the presentation.
Yeah, it won't do that during.
I'm gonna sit over there though, I think.
So do you wanna open YouTube and I can take? No.
My mom and dad.
Oh, and I don't have to admit myself, because I guess I defaultly.
I do hear playback though. Can you hear me? It's like echoey.
Yeah, but it's right there. Pretty.
If you were doing an hour-long presentation, would you like to hear everything you said echoed after you said it?
Something.
Oh, I thought you were talking.
You have to.
Sound any better?
No, you're getting feedback too. How do you turn this off? Oh, this is bad.
Turn the volume down. Yes.
Oh, yeah, why didn't you just turn it off? Feedback?
Hello?
Did everybody do it
Gotten 1, 2, 3 so far.
then?
But he's saying we weren't coming.
Test.
What are you testing? You guys eat dinner before then?
I ate my lunch for me.
Yeah, I scarfed down my food for it.
I didn't do it, it felt weird, it's like 4:30, eating dinner. I was like, I'm not even hungry.
Hey, John, Chuck, or Pete, can you guys hear us?
I can.
Okay.
There's two of you.
Yeah, Amanda's going to use one of them for a presentation.
Ah.
We were just
Hello,
testing.
Johnny.
Hello.
How are you?
Good. Can you hear me? Okay.
Yeah.
We'll give it a few more minutes to see if anyone else joins for the training.
No, I don't. Oh, you mean like on Zoom?
Where's your water? Is your water,
It is 6 o'clock if you guys want to start.
Let's go for it, Cameron.
We're doing a little test of the audio. Can you hear us?
Yes.
Yes.
All right, it's 6 o'clock. We'll go ahead and get started.
Good evening, everyone. Do you want me to go ahead and start?
Yep.
Okay. I believe we've shared the screen, and you can see the presentation that I've prepared, the Planning and Zoning Commission training. I am also the admin on this computer I'm using, so I will have to monitor anyone who needs admitted. So if I pause, that might be why. A brief introduction of myself for those of you who don't know me. I did one prior training for the Planning and Zoning Commission, but it was while or before some of you were on this commission. I'm Amanda Calloway. I'm the city attorney for Ozark, Missouri. And prior to this, I was an assistant city attorney in Springfield, Missouri. And I came to the city of Ozark in 2017. And I've really enjoyed getting to work with all the city departments, including planning and development. In that role, I provide assistance to commissions and boards, such as the Board of Aldermen, the Board of Adjustment, and the Planning and Zoning Commission. So I've prepared this training. We're going to get into a little bit of the details behind the role that the commission serves. And if you have any questions, you may have to withhold them until the end. I can't see all of the participants due to running the presentation, but I am always happy to provide you with answers. And at the end, if you have any questions, we can always address them. Okay, technical problems here, all right. All right, so you've been appointed to the Planning and Zoning Commission. What does that mean? Section 410 of the state law says how a Planning and Zoning Commissioner gets appointed. They are appointed for a fourth-class city, which Ozark is a fourth-class city, by the mayor, and they must be a resident of Ozark. They are appointed for a 4-year term, and the commission itself cannot have more than 15 or less than 7 members. But within that frame, you can have anywhere between that. Well, the mayor and 1 Board of Aldermen member may sit on the commission. However, if that occurs, then you have no more than 15 and no less than 5 if they do sit on the commission. All right, so you may be asking yourself, especially if you're a new member, I've been appointed to this role, I'm on the Planning and Zoning Commission, but what do I really do? You know, what's my function? Well, states authorize the establishment of a commission of appointed, however, not elected commissioners. So you're not technically legislators, that would be the role of the Board of Aldermen. So your role is really to recommend decisions to the Board of Aldermen, really like the first line of defense for planning and zoning matters. So the next natural question is, okay, so now I kind of get what my role is, but how do I fulfill this role? Well, there's really two main goals. The purpose of the regulations, which we will really go into a lot of depth related to that, and then holding effective meetings, which I cover briefly at the end. And with those two components, you really should be able to utilize the role of a commissioner very effectively. A little bit of background, and I found this particularly interesting. Planning and zoning hasn't been around that long. Prior to 1910, we had no regulations for planning and zoning. In 1916, we saw that New York adopted the first generally recognized comprehensive zoning code. In 1921, the U.S. Department of Commerce organized an advisory committee to actually draft model planning and zoning acts to be used by the states. So it wasn't until between 1924 and 1928 that we actually saw model acts provided. In those model acts, you'll see that there's two of them. There's a standard state zoning enabling act, and then there's a standard city planning enabling act. They each were revised then in subsequent years. Almost all states have adopted zoning enabling acts that were descendants of or influenced by the standard state zoning enabling act. So you'll see that we'll get into a brief discussion about the laws that we follow for planning and zoning, but those really were established by this one document. And so our laws are not that different from other states. The model principles that are generally adopted by most states are listed here. They include the delegation of the zoning power to local government. So you'll notice that on the state level, they don't get involved on local issues. While the state statutes may impact municipalities, they aren't making the day-to-day decisions about zoning and land use. The power to initially divide the local government's territory into districts, a statement of purpose for zoning regulations, the authorization for a board of adjustment, which serves as a quasi-judicial board that reviews requests for variances, and the authorization for the adoption of enforcement mechanisms. So, as a planning and zoning commissioner, you may be familiar that our city is broken up into generally different zoning districts. And it's not hard if you look at an aerial map, you would probably be able to figure that out. We have residential areas, and then we have commercial areas, and we have industrial areas. And those are just some basic ways that they're broken out. And that's something you see across the United States. However, if you go farther east, you may see it being, since the laws were adopted after some of those areas were already established, you may see those districts not as neatly organized. But what we call this is called Euclidean zoning, and it's from the case that's cited there. And that case established that that was an appropriate way to group uses for the purpose of managing how cities develop. And how we do that is it's characterized by the division of the local government's jurisdiction into uniform districts. And they regulate it by density, bulk, and use in a consistent manner in each district. After World War II, we saw some further development in planning and zoning laws. So we saw a lot of flexibility added to these laws. We developed overlay zoning, which allows for districts a second layer of regulation to essentially float over the underlying district, floating zones, special districts. I put an example in here of that locally would be the historic district. Incentive-based zoning, that could be a CID, community improvement district, or a transportation development district, or even a neighborhood district. And a planned zoning district, in Ozark we call this a planned, a PUD with mixed uses. And this is something that Missouri courts have actually upheld as being more progressive and more modern. But this is where you would have Uses that may not normally be situated together in close proximity in a residential, commercial development where you have that mixed use situated close. So in Missouri, the state statutes that authorize zoning, I've included the link that you can use if you ever want to look at the state law, and I would encourage you to do so. It's in Chapter 89, and that's for all municipalities. So Chapter 89 really holds all of the powers that a planning and zoning commission has. And then in addition to that, there is a separate section related to annexations. And so I've given you that as well. You can find that at the same link. All of the state laws are located there. The annexation laws are found in section 7112 and 7115. Locally, we have several chapters that govern planning and zoning. We have City Code Chapter 400, which covers all the commissions and boards. City Code Chapter 405, which is really the bulk of the zoning material. City Code Chapter 407, which governs signs. And City Code Chapter 410, which regulates subdivisions. So why do we have zoning? Why is it important? And I found this quote as I was doing research for this presentation, and I thought it gave kind of a clear picture. But the quote goes, "We want to keep the pig out of the parlor. So we want to control land use. We want to make sure that when we have applications for development, whether that be residential or commercial, that we have a plan for how we're going to utilize the land that's available for that development. And we have to have a little bit of forethought. So we create what's called a comprehensive plan. And then we have laws and regulations so we can enforce those zoning uses in that area. So the first step, I already mentioned it, but that would be the comprehensive plan. And that's where you adopt what your different zones and where you would like to see them and what they're going to look like. The key here, and you'll hear this throughout the presentation, is uniformity. So one district may have different restrictions from all other districts, but within that district, the application of those regulations must be the same. So you can't treat two commercial properties different from each other. And so we just need to keep in mind as we move forward that really uniformity is the key factor. So the first thing is the comprehensive plan. And Ozark just reviewed our comprehensive plan a few years ago. So some of you might have been involved in that process and you may have a better understanding of it. But the comprehensive plan is a roadmap for what districts are desirable in specific locations. And usually it involves some public input where you ask the citizens to speak to where they want to see different zones. And it is required to have a comprehensive plan if you're going to have a planning and zoning commission. So that's something you have to have. It is adopted via a resolution and not an ordinance. So the importance there is it's an administrative expression, but it's not a law. So when we think of the comprehensive plan, it's important to note that it's not something that we have to abide by steadfastly, but it is what we'd like to see desired in terms of how our city is going to grow. So we will refer to it and we use it to help us plan, because when you're planning how to develop a city, you obviously need to have something that maps that out, but it's also not something that's going to be strictly enforced. So what's a comprehensive plan do? The plan is used to assist with the physical development of the municipality. Again, it's not a strict blueprint. It includes the general location and character, the extent of streets and other public ways, public grounds, places, and spaces, as well as locations for public and private utilities. It also includes the regulations of height, area, bulk, location, and the use of private, nonprofit, and public structures, and premises of population density. So it covers a lot. And just a note on my slides, I'm very familiar that I am a fast talker. The slides, when I create them, I try to put all of the information that you would ever need so that you can refer back to it and you can use it as a tool moving forward. I have attended presentations where individuals have spoken too fast and had slides that had no material on them, and then it is virtually worthless to me in the future So I try to recognize that in myself and provide that information to you so you can use it. So I do apologize if I speak quickly, but all of the information I guarantee is in the slides. So the next question is administrative versus legislative. And why is this important? So there are two types of functions that you will serve in your role as a commissioner on the Planning and Zoning Commission. One is legislative and one is administrative. And it's not the body that makes the decision that determines it. So some people may think or assume that the Board of Aldermen serves only a legislative function and only the Planning and Zoning Commission serves an administrative function. However, both boards will serve both functions. So you really need to stop and ask yourself what hat you are wearing when you're making a decision that comes before the Planning and Zoning Commission. So I always like to think, am I wearing my legislative hat or am I wearing my administrative hat? And then use what I teach you moving forward and how you analyze what's being asked in the application and the decision that you make. So I know I haven't told you which is which, but we will get to that. It's just important to recognize there are two different functions and they are very different in terms of the discretion that you have in making a decision. So the standard of review for an administrative versus a legislative decision is really a huge difference. And that's something that makes it extremely important to understand. The legislative decision is typically going to be a zoning or an annexation decision. And how the courts look at this is it's a fairly debatable test. Now, that in of itself sounds confusing, but I've tried to break it down for you. So it means that if the reasonableness or the constitutionality of the zoning regulation is fairly debatable, the zoning regulation will stand. So the courts, you see, they will presume that the zoning ordinance is valid, meaning it shifts the burden to the attacking party or the opposing party to prove that that regulation is unreasonable. So you go into a challenge to a legislative decision already ahead because the other party has a burden to prove that your regulation you are enforcing is not fairly debatable. So those types of decisions, you would seem to think that you have a little bit more leeway. An administrative or a ministerial decision. This is what we do when we look at platting or subdivision, site plans, and some other functions, including some that are more related to some components of zoning. So don't get it so, I guess, lined out in your mind that all zoning decisions are legislative. We will cover some that would be more administrative. But administrative or ministerial decisions will be reviewed in terms of the factual basis for the decision must be supported by substantial and competent evidence based on the whole record. So what does that mean? That means that the court's going to look at the meeting, the minutes from the meeting, and they're going to try to see, why did you make the decision that you made? And generally, administrative and ministerial decisions are going to follow a checklist. So for example, subdivision regulations, they have a checklist in the city code. And the city code is adopted after it goes to the Planning and Zoning Commission for review, and then after the Board of Aldermen. So they expect that if there's something that you want to see in the subdivision, that you would put it in the code. And then once you get to that step, you check all the boxes and you move forward. So really, there's not a lot of room to state that you're not going to approve something unless those boxes are unchecked. So I've made this diagram here, very simple, but I thought it represented, as we walk through the three major functions of municipal planning, how we should look at these. So annexation is the broadest. We have a lot of discretion with annexation because the land isn't part of your city yet. And so you have a decision whether you want that land to become part of your city. And zoning, we get a little narrower. We have laws related to zoning and what those uses look like. And those laws are in our code and both boards have passed them. So we have to adhere to those. So our decision-making gets a little narrower because we're applying those laws. And then you see we get down to subdivision or site plan, and that's right down at the bottom of the triangle. And we have really narrowed the scope of what we can apply. We have the laws that we've enacted, and again, we have those boxes that we're checking. And at that point, we don't have a whole lot that we consider outside of that. So as you move through the annexation, zoning, and subdivision or site plan phase, you might keep that in mind in terms of how much you have to consider when you're making that decision. So first, we will discuss annexation. Annexation, as I mentioned, it's found in state law in section 7112. And it sets forth what has to happen for a property to become part of a municipality. So first, it has to be compact and contiguous, and that is a pretty rigorous standard as it is set forth in the state law. And we won't get into the details of that because staff will generally review those, and we will bring forward a determination as to whether it is compact and contiguous. Generally, you don't want to see any flagpoles. So when I say that, it means that you're going to annex a long, narrow strip just to get to the parcel that you are bringing into the city. And you also don't want to see any donut holes. And that means that you're going to annex all around a property and leave that property out. You are technically required in that situation to ask the property that would be left out or create the donut hole if they would like to come in addition, and then you bring them forward at the same time. There's nothing that requires them to do so. It does require that the petition for annexation be notarized. And I have all in all capitals there because you may think that annexations come in separately, but actually they can be brought in together. So you can have multiple properties brought in at the same time. You just have to have all record owners for those parcels signing the notarized petition. You, as the Planning and Zoning Commission, I have listed here what the Board of Aldermen does, but really the authority on annexation would come into play with a policy on whether you're gonna limit some or all annexations. And I have a note here related to tiers, and that's from a presentation where we discussed where we wanted our priorities to be related to the sewer and water system. But that's one way that you can kind of organize that is if you're likely going to be developing your infrastructure so that it will be accessible by certain properties that are not presently annexed, you could come up with a map of properties that would be desirable to be annexed, and then some that might be maybe further down the road because they're farther out. The annexation nuts and bolts is on this page. So there is a pretty stringent notice requirement. So you have to publish in a newspaper of general circulation at least 7 days prior to the public hearing. Now, you'll want to note that the public hearing, while you have one at Planning and Zoning, it is a formal public hearing at the Board of Aldermen. So that's where we hold our formal public hearing as I refer to it in this presentation. The timing of the Board of Aldermen public hearing must not be less than 14 days and not more than 60 days after the petition is received by the city. And the hearing must be held not less than 7 days after that notice that I mentioned has been published. So you may be familiar with the calendar that the Planning and Development Department publishes on its website and provides to developers. That calendar does a really good job, and it's an important function because it backs up this timeline so that developers can see how they can meet that requirement by all of the meetings that they want to come to. So we've kind of taken that work in advance and provided that to them so they can map out their application. Protesting an annexation requires 5% of the qualified voters of the whole city, or it can be 2 qualified voters within the area that is going to be annexed. Now, that one does not frequently happen. Generally, when we are annexing property that has people already living on it, that property is part of something called a consent to annex agreement. That's a contract where the city has agreed to provide services such as water or sewer to the property, and then the property owner then agrees at some point, usually when they become compact and contiguous, that they will be brought into the city. So we don't frequently see anyone living within a proposed annexation site protesting it. It is more likely to have the qualified voters protest it, but 5% is a large number to a burden to meet. The other note is that the objection itself must be filed with the city no later than 14 days after the public hearing. So since the public hearing is at the Board of Aldermen and it is at the first reading, there is no way that an annexation can be read twice at the first reading. That is why we always state that the annexation will be held over until the second reading, because you have to allow those 14 days for people to submit their protest petition to the city clerk. And that lines up with 2 weeks between meetings. All right, now on to the next more exciting kind of element related to planning and zoning, the zoning. I have this quote in here. It comes from a case, and I thought it summed up some points about zoning very nicely. So I'll read that to you. Zoning is lawful when it bears substantial relation to the public welfare. If the public welfare is not served by the zoning, or if the public interest served by the zoning is greatly outweighed by the detriment to private interests, the zoning is considered to be arbitrary and unreasonable, and therefore in violation of the due process clauses of our state and federal constitutions. Public welfare encompasses the entire municipality, not just those neighboring properties. I really like that quote because it sums up all that zoning has to do in terms of the balance between the private interest and the public interest and whose interests are where. I think it's important to note, I did add the clarification there that the private interest would be the applicant making the request, not just those people who attend the hearing who may be in opposition or favor, but unrelated to the applicant. There are several factors that a court will take into consideration when balancing the public and private interests. And no single factor is considered determinative or controlling for that purpose. So we don't look at these as, oh, you missed factor number 2, therefore it's not going to go in your favor. It's just a guidance that courts have given. And when I say that, in my research, the case law related to zoning will be very case by case. So this is really the best guidance we have, which is why I'm providing it to you. But just keep in mind that there's no exact science related to this, but this is kind of how we can view zoning moving forward, and hopefully it'll help us make good decisions. The adaptability of the property for the permitted use can be reviewed. The effect of the zoning on the value of that property, meaning the property that the applicant is applying to change the zoning for. The zoning and use of the property surrounding the subject property, and the effect that the removal of the current zoning would have on the other properties in the area. So courts have clarified that the use does not include the feasibility of the actual plan. So like if they're going to put in a large commercial store, that would not necessarily be taken into consideration with the request. It would just be that it is a commercial use. It wouldn't be that, for example, if a Target was going to locate there, you wouldn't be taking that into consideration, just that it is a large commercial venture. So with zoning, if we back up, as you saw at the beginning of the presentation, we have already established a comprehensive plan, and that says where we want these uses to be located in our city. They're grouped together, it's organized, and why do we do that? It goes back to the pig in the parlor quote. It's because you don't want an industrial use right next to a residential use, because those two uses will not be good neighbors. They will likely, you will see conflict arise. And so we want to alleviate that conflict as much as possible by predetermining where we want to see these uses located within our city. So then we have the permitted uses established in the city code. And what does that mean? That means that you have determined where they're going to go, and now you're going to determine how you're going to regulate them. And those regulations are in chapter 405 that I mentioned earlier in your city code. And those are laws that you've adopted as a planning and zoning commission and the board of aldermen has adopted. And those are the rules. That's what the zones, that's what they're gonna have to abide by. And as you apply the zoning code to specific properties, that's how you're effectuating that law that you've already put in place. Conditional uses, this is the one where I referenced that sometimes zoning, you have to switch hats because some zoning will be legislative. In conditional use, that would be more of an administrative capacity. So a conditional use is administrative, and what happens here is you have a use that fits into the zoning. However, there are some things related to that where you feel that there may be nuisances created or concerns within the zone. And so you want to place further restrictions on it so that those nuisances or concerns don't occur. And that's where if the conditional use applicant meets all of the requirements for the conditional use that you've placed in the city code, they would check all of those boxes and they would be approved. Really, regardless of whether, there's maybe an objection to that conditional use. I think it's important to cover the limitations on zoning because you really want to know this before you have to know it. And the way you have to know it would be as if you find yourself testifying in court related to a lawsuit. So I personally find the constitutional law very interesting, but I think it's also important just to understand the limitations. So the Fifth Amendment to the United States Constitution, also in our state constitution, would prohibit the taking of private property without just compensation and the deprivation of a person's property without due process of law. So we normally think about this whenever you see a city or a state or maybe even the federal government take someone's property to build a road, or they take it to build a bridge. And you see that where they condemn the property and then they pay the individual just compensation, or they should, for that property. However, in zoning law, you also have an element of taking, because if a zoning regulation is applied to a property, so that the impact of that zoning regulation would deprive the individual, it would be so burdensome that it takes away the value of the property. It could also violate this constitutional guarantee, and there was no just compensation given, and now you have damages. So in this regard, the Fifth Amendment applies to zoning, and that's important to take into consideration as you apply the zoning regulation, or even a request for a zoning change. The 14th Amendment I reference because that's how the federal constitution applies to states and local governments. And if you thought limitations was limited to one slide, it is not. It is multiple slides, but that's important. It's always good to know the power you have and then also the limitations on it. So due process claims. There are two types of due process claims. First will be procedural, and this one's really easy to meet the standards. So the city's gonna take care of that for you. It's the notice. So the city's gonna publish the notice, and we're gonna make sure that we meet those requirements that are listed in the statutes for when the Board of Aldermen hearing must be, and we will for sure provide the notice to the citizens. The second element is really up to the board, both the Board of Aldermen and the Planning and Zoning Commission. And that is, once the notice is provided and you have citizens attend the meeting, you have to give them an opportunity to speak. And that means that the individual can really stand up and speak to whatever element they want to about the property or the question being asked of the Planning and Zoning Commission. I think a key here, and this is something that I try to remember when I'm presenting things to the Board of Aldermen and the public ask questions, is that not all of the questions have to be answered. Sometimes they just want to make a statement, and sometimes there is really no answer to be provided. I know we kind of live in a society where we want to provide the answers, and as in the work that we do for the government, we want to give the answers, but sometimes the key is just to let them speak. Now, there are some planning and zoning items that draw large attendance, and I don't believe anyone would be having due process met if they were at a meeting that lasted until 2 a.m. So I think it is important to create as a board, and you may already have this, but some rules about how they speak. And some of those rules, you can use the ones that the Board of Aldermen have. That would be a 5-minute limitation on public comment, or you can reduce that if you feel like that's important to you to 2 minutes or whatever you feel is appropriate. The key would be uniformity and adopting that as a rule moving forward. So we want that noted in your minutes, and then staff can keep track of that as you move forward and provide that to anyone who attends in person or electronically via Zoom. The substantive due process claim would be if there was a decision made and it was made for reasons beyond the scope that the zoning code allows you to make them. So that would mean that there's an arbitrary and capricious decision. That's where we make a decision and it's not based on any of the regulations in the city law, and it may have been influenced by the public or potentially like political reasons. So it's not, it's a hard one to describe, but generally if the zoning code has been met and there's other issues being presented, that's where you see a caution flag, and you should be thinking, is this really arbitrary to what I'm deciding? And if it is, it may be ideal to review that with staff, and we can try to provide you guidance as to what considerations can be made under our code. It's important to note too that if there are additional considerations that are legal, we can always amend the code. The code itself is a living document. We can update that. And it certainly has been updated over the past few years through requests of the planning department. And I think that's important to note that you can make those recommendations to staff, and we will certainly take those forward to the Board of Aldermen for their consideration. Another limitation is the equal protection claim. This is where a zoning regulation would treat one or a few parcels of property differently from similarly situated properties with no justification. So this goes back to that first or second slide where I said uniformity is key. So you don't want to have two different sets of rules for two commercial properties. You really want to follow the same rules for all of the similar properties. For an equal protection claim to be valid, it must affect a fundamental right or a suspect classification, unless the action is actually irrational and wholly arbitrary. So we get that arbitrary standard again. So if the difference is that, we just don't like, I'll pick a name, but I hope nobody has to, I'll say Cameron Smith, but we just don't like him and we don't want to do that, that's where you reach that irrational and wholly arbitrary. And I don't believe that would ever happen, but that's what they're talking about there. And you're not talking about a class of people in and of itself that would be protected. Limitations, and I think this is the last slide of the limitations. We have First Amendment of the U.S. Constitution that has to be considered in zoning. And you might be thinking, how does that have anything to do with zoning? If the zoning regulation improperly restricts freedoms of speech or religion, there may be a cause for a claim. Additionally, freedom of speech claims are generally tied to sign regulations. I did note that there is a more recent, in 2015, there was a U.S. Supreme Court case referred to as Reed. It was the individual's name who brought the lawsuit. So the Reed case is a newer case that really places restrictions on how signs can be regulated, because there was an issue with offending the First Amendment of the Constitution. So that's something to take into consideration, since the sign regulations would impact some zoning cases. We also have some others that I've listed, including the Federal Land Policy and Management Act, the Fair Housing Act, the Freedom of Religion claims that may be brought under the Religious Land Use and Institutionalized Persons Act of 2000. So there are other claims that may be brought, although likely less frequent. So the nuts and bolts for zoning related to notice, I've included the statute section, but it requires that there be at least 15 days for the time and place of the public hearing be published in a newspaper of general circulation. Again, the public hearing will be the Board of Aldermen first reading of the bill. And so the calendar, again, that planning and development created, establishes those dates so that those timings are met. And then we place it on the Planning and Zoning Commission calendar that matches that. This would include a request for rezoning, amendments to the actual zoning code, any changes to a zone, anything that just generally relates to zoning. I know it sounds obvious, but it actually encompasses more than you would assume. A protest for a zoning is very interesting, and I'll explain it the best I can, but I may provide you with something in the future that kind of gives you a representation of it. It must be signed by owners of 30% or more of the areas of land. So that's key. It's not 30% of the owners, it's 30% of the land. So you get a petition and you have to draw where the property that is being, like the request is related to. And then you draw an outline around it, 180 feet all the way around it. So you kind of create like two circles. And then you take all of the people who have submitted protests, and you have to add up their areas of land and determine if it's 30%. Very interesting way to conduct a protest, but all it results in is it would require a 2/3 favorable vote by the Board of Aldermen. A very interesting protest process that's established in our state law, but very complicated nonetheless. So the subdivision process, now we're down at the narrow point of that triangle. I showed you the upside down triangle. And we've really gotten to the place where we're thinking more administratively than legislatively. And it's really important that we focus on the city code sections related to subdivision. So generally, again, I referenced the Board of Aldermen. However, it would be the same for the Planning and Zoning Commission. They're going to be looking at whether all of those requirements are met. There is a section in your subdivision code that sets forth everything that has to be in a preliminary plat, and that's what you would be looking for in your for your subdivision. And again, I had noted on the other slide that if you're thinking about where does your authority lie in that, it's amending that code section. So as much as you want, you can place additional requirements in the code, and then you can require the subdivision applications to meet those requirements, and we will provide you guidance on whether those requirements are legal. But the importance is that they're actually in the code and you're checking that box. We can't just be doing that from time to time, depending on who's applying. And that's the tricky part about subdivision approval, because it has to be, you have to think ahead and you have to put in your law what you desire. An example of that would be traffic impact studies. You know, the city listened to the requests of our elected officials, and we've reviewed the traffic studies and how we can incorporate those into the subdivision process. That brings me to the next subject, which is tied to the traffic study, and that's exactions. So this really goes beyond the scope of planning and zoning, but a lot of times, from what I've seen, a lot of people come to planning and zoning as neighbors of a proposed development, and they present you with a lot of concerns. And a lot of these concerns are fear-based, which is natural. They're concerned about stormwater, they're concerned about traffic, and they have questions. Well, a lot of times the traffic or those improvements, it's stated that we will do a study and we will see how much the developer has to build. Well, that's not entirely true. So the US Supreme Court has come in, and some municipalities were requiring developers to build extreme off-site improvements. And those off-site improvements are tied to the approvals that the Planning and Development Department would give them. So you can see a situation here where some departments would withhold the approvals before they built these improvements, although the improvements greatly exceeded the impact that that development was going to have. So we have a set of cases, and these cases are very fundamental to planning. And they set up what the analysis has to be if you are going to require a developer to make off-site improvements. You may be asking, why is this important? It's important to municipalities because if the traffic study supports some improvements, but not all improvements, the municipality itself will have to fund those improvements. So it will have to be a public-private partnership to effectuate the improvements, because you can't burden the developer with 100% of that cost. So how do we decide if these improvements are going to be tied to the development? Because I would say there's a big difference between building a shopping mall versus maybe a fast food restaurant. You know, you're going to have different loads of traffic going to those locations. So the U.S. Supreme Court has generally stated that to determine the constitutionality of a dedication or a requirement related to off-site improvements would be if there's an essential nexus to the public purpose that would be served by denying the permit, but also through rough proportionality to that public purpose. So what does that mean? That's the essential nexus. That's always a tricky one to determine. I've included it here, and I won't bore you with the details, but these cases are extremely interesting if you ever do want to read about them. You've got kind of a test here that I've given you, and this is the same test I've given to the Planning and Zoning Department and to Public Works, and this is the analysis that you would run through if you were going to consider whether offsite improvements were warranted. So Nolan is the first case, and that requires that the condition bears an essential nexus to the reason for requiring the permit. So you have to identify, like, what's the public problem? Is there not enough, are there not enough lanes? Is there a need for a traffic light? Maybe it's a sidewalk issue. One of these cases did deal with public access to a beach. You have to show that the proposed development itself will create or make the situation worse. You have to show that the condition solves or alleviates the identified problem. Then the second case is Dolan, and it requires that the condition is roughly proportional to the impact of the development. So if you're putting in something that's relatively small, you can't say, well, we need a 4-lane road that has a stoplight. Maybe it would warrant an extra turn lane, but maybe that full intersection is not warranted. So you have to actually show that the number of vehicles coming to the development would be proportional to the improvement you're requiring them to make. And the last case is called Kuntz, and that case, it says that in some municipalities, the city said, well, give us money and we will hold the money and then we will build the improvement later. And you can do what's called like a buyout or an escrow. And this case said that that's not appropriate if you cannot tie the money back to the actual area that was being developed, and it has to be proportional. So you have to still meet all those same requirements. This would be like a sidewalk program or something of that nature. All right, so we're through all of the planning and zoning material. Now we're to how do you conduct a hearing. Effective hearings are tricky. You have a lot of public input, people, there's a lot of emotions. And so in order to hold orderly hearings, I've put some ideas down. I believe you follow potentially Robert's Rules of Order, and we've provided some of that material to you. Robert's Rules, though, in of itself can be cumbersome to understand. So when you're thinking about Robert's Rules, I would focus on just the main motions and portions related to that, and just trying to make sure it is just a clear communication of what the board is doing. And again, remember, going back to the limitations on zoning, you want to make sure that you have the opportunity for the public to speak. So it's vital to obtain the facts, to remain impartial, and have a record. Now, the record does not have to be verbatim, and in fact, that's actually discouraged. It is nice to have the recorded meetings. I think that's wonderful for a purpose of anyone who wants to go back and watch this training specifically, or other meetings. But what it means is you need to be able to look at the minutes and see who was at the meeting, what decisions were made, who voted on them, who spoke towards it. You should get a feel for what happened with each agenda item, but you don't need to know every detail of what was said. You get a good idea, but you don't have to have it written down for me. This is a slide. I did not mean for it to do this, and it was much more fancy than I know how to operate, but I think I've loaded it all on there. You can, in advance, provide the rules for speaking. I think that is already done. I really commend the presiding commissioner for that. Running an effective hearing is telling everyone that at the meeting that we're all going to abide by these rules, you know, like the 5-minute speaking, and that we're going to have decorum. Decorum in different jurisdictions can mean different things. I come from a background where staff was not spoken to by the public. It was directed to whichever board was in charge. I think that provides for a nice buffer. And then the board is always going to ask the staff questions then maybe in response to that. But it alleviates any tension between the public and the staff. And then obviously decorum amongst members. Members don't have to agree. That's why you're on the board, so we can hear your ideas and thoughts. But it is important that everybody treat each other with respect, even if you are opposing each other on those decisions. There's generally going to be an opportunity for both sides. When I say both sides, I mean the applicant and the public to speak. It is customary for the applicant maybe to have a rebuttal, and that is provided, I think, at the discretion of the presiding commissioner. The findings of fact. I believe you are provided a sheet that gives you findings of fact for different things. Generally, you can utilize the staff report. You have a fantastic staff that give you detailed reports on the property that even include pictures and a lot of information that I actually haven't seen in some zoning cases. So I think that's really beneficial to use that, and you will have a good grasp moving forward about whether the boxes are checked on the application or if it meets your planning and zoning code that you've adopted. You can always refer back to this presentation, or I'd be happy to talk to you about if you had specific questions about a specific application. And then always remember, if you don't like something in the code, you can always amend the code. You get to recommend the amendment. The Board of Aldermen certainly take that into consideration whenever they review your proposed amendments. So I think that that's important to keep in mind, that as the city grows and evolves, you can always go back and review your city code and your ordinances, because what was maybe beneficial to the city 20 years ago needs to be updated, and we need to modernize the code to reflect the current status. So I thought it was also important to include findings of fact, like what's not important. And I know this is a hard one because you, again, are always caught in a lot of emotional testimony, and that's difficult. I have difficulty with that in the capacity of being a prosecutor. I'm constantly involved in some emotional discussions with defendants, and that can be wearing. So when we're thinking about planning and zoning, though, the fears and the desires and the number of people in opposition or even in favor of, or promises, or even personal characteristics of some of the participants, those can be swaying sometimes, and it may feel as if you're outnumbered on the board by the number of people in the room, maybe on one side or another. But again, going back to the tools that I've given you and the tools you already have, and utilizing that moving forward, that will keep you from being challenged in court, or it'll help you win if you are challenged in court. And so I think it's just important to remember that while it's definitely, we have empathy for some of the people and what they express, it's not always the deciding factor. And I have a slide for questions. I'm not sure how I would facilitate that. I may have to rely on a camera, but I would be certainly happy to provide any answers in response to this presentation, or any questions you have about planning and zoning at a future date, or I could even try to do that now, but I will, at that, I will.
So yeah, anyone has questions, chime in, speak up. We've got about 7 minutes before we start a regular meeting. So please ask away, or if you want to jot those down, we can answer those at a later time.
I have a question on the January meeting, which was my very first meeting. There was an issue regarding water runoff from a subdivision being built. What is the next process in determining, I guess is it a staff issue that determines how the excess water is going to go off the property? Kind of what happens with public complaints like that?
Do you want me to answer that?
You can start, I can.
Okay. I'm not sure specifically at what point that application came forward, if it was a plating, application. What was the plating?
Potentially it was a plating, and I can add to that. So I think what you're asking is kind of, when is it appropriate to evaluate design elements or criteria that's based on the improvements being proposed on the project? So in that application, so those particular items would come up during the subdivision process, not the annexation and not the zoning process. And a lot of that, you are correct. You're relying on staff to evaluate their proposal based on the design standards that's put in place either by the zoning ordinances or the public works design standards. So in most of those cases, staff does evaluate that internally or with our third-party consultants to make sure they are complying with those requirements. A lot of the stuff isn't finalized or completely determined during the planning because, again, it's a sketch plan. They haven't actually had an opportunity or invested in an opportunity to come up with a final design. And so those will start being refined during the construction drawings that are submitted to staff for review. Upon approval of like a preliminary plat, that is when an applicant, Joe, will get into the details of those required construction improvements. Not sure if that answers your question directly, but that's kind of how it's evaluated throughout the process of review.
I kind of had a question on that same issue, a couple of different questions about the decisions that we made. And first of all, I guess my first question's on slide 17 about annexation, and it talks about a flagpole. And I must have missed that. Could you describe that again, what that means? I think I have an idea, but I want to make sure.
Yes, you may have an idea because there are examples of that in the surrounding areas. The flagpole annexation would be where you have a narrow strip of land that then connects to a larger strip, creating like a flagpole. So I talk with my hands and I'm kind of drawing it out, but if you think of what a flagpole looks like, you would have that narrow strip and then the piece of land attached to it. You want to avoid that. So you really want to have your city built out like a larger bulk, and then you're adding to the outside of that as opposed to a narrow strip, because you're going to have a situation where you have to run utilities to that and services like police, and if you had a fire department. And whenever the city certifies that they can annex property, they also are certified they can provide those services. So if you overextend your boundaries, you're putting the burden on the services which the taxpayers are paying for.
So if that has happened in the past, and then we're approached about an annexation that is then attached to that piece of land because they say now it's contiguous, but they're surrounded on all the other sides by unannexed land, are we obligated to bring them into the city because of that attachment to that piece that should never have been attached like that?
You're not technically obligated to bring anyone into the city. There are times where it's more advantageous to do so, like I explained, where you're providing city services, because you want to have those individuals as citizens. But the way that the city of Ozark is currently, our boundaries, we do have a lot of unincorporated areas, and we kind of look like a capital I within a middle section. And we're trying to fill those in so that the services we've already provided can be utilized. So I think in some situations, the answer to your question would be, yes, it is appropriate because we've already provided sewer and water, and the police are already, answering calls to this area. So it's not going to be overly burdensome. However, if you had a an area that maybe wasn't as close to others, you could consider that. But it really goes back to whether those services can be provided. And that's how I think about it. You know, assuming that the compact and contiguous requirement was also met. There's a very specific requirement in the statute about exactly how much land is required, and it has to be measured a certain way for you to attach to it.
Okay. And then my other question that has to do kind of with a zoning question as well is, so say there's a piece of ground and they approach about being included, annexed into the city, and it would be annexed as a certain zone. But then they come back a few months later and want that zoning changed. So when we are annexing a piece of land as a certain zone, and we understand somewhat the impact that it would have on streets, traffic, water, all of those things. But then they come back later and expect to have their zoning changed to make it more, to make it more dense. Can we reconsider the amount of wear and tear and all the public utilities it will cause to make it more densely zoned?
Amanda, if I may, before you answer that, the length of time you're going to answer that, we're already at 7 o'clock, which means that legally we're supposed to be doing our planning and zoning meeting. If you want to answer that, please go right ahead. If you can answer it in a short, concise manner, please.
Okay. The short and concise is going to be the tricky part. That was a complicated question, but as you know, we amended our zoning code to annex property and then separate the zoning. So presently, the annexation comes in as the county zoning. They can immediately apply for a rezoning. And at that time, you're only going to be considering for the annexation whether it's compact and contiguous, and whether you can provide those city services. So really, the use of the property is not as determinative at that stage. I think I understand what you're getting at in terms of the impact that the development may have. However, that's going to be at a much later stage than either zoning or the annexation. So you may hear about that from people, and that's appropriate for them to comment on at the public hearing. However, that is probably outside the scope of the question that's being asked at the time of the board.
Okay, well, if anyone has any additional questions, I would suggest you just give Amanda an email, and I'm sure she'll get back to you in a timely manner. I want to thank you, Amanda, pardon me, for taking the time and effort and research it took to put this training together. I'm very glad that we had that conversation a few months ago where we can get this started, and some kind of an ongoing training program would be great to have as we move forward. Certainly nothing as in depth as what you did tonight. But I do appreciate everything that you've done. It certainly shed a lot of light on some subjects that we've been addressing of late. So I'm assuming that the commission, based on the things that you said and what they read, it will help them make different types of decisions based on the training that they've received tonight. So thank you very much.
You're welcome, and I'm always happy to help. That's my role, so feel free to email me or call me with any questions.
Great, good deal. Thank you. Again, if anyone has any additional questions, please do not hesitate to reach out to Amanda or anybody from staff, and they'll get back to you. So here we go. Let's fire up the April Planning and Zoning meeting. The first thing up is the approval of minutes for the previous meeting. If everyone has had an opportunity to review, if there are any additions or deletions, please state. Otherwise, I would entertain a motion.
My motion to accept the minutes as written.
We have a motion on the floor by Commissioner Garrison to accept the minutes as written. Do I have a second?
Second.
We have a second by Commissioner Oakes. All in favor? Raise your hand. Okay, good deal. Thank you. No scheduled visitors, no unfinished business. Under new business, first up, letter A is the election of a chairperson. So we need a nomination.
I nominate Chuck Branch. to
We
be
have a motion on the floor to nominate the sitting chair for another 12-month term. Do we have a second?
I'll
Second,
second it. I say,
We have a second. Any further discussion? Roll call vote, please.
Dean Hutchinson,
Aye.
Jeff Garrison,
aye.
John Dillon,
aye,
Wim Oaks,
Aye.
and Pete Renfro.
Aye.
The ayes have it.
Okay, very good. Thank you. I will continue to do my best representing the Planning and Zoning Commission with the city and with developers. Okay, next up is letter B, which is a preliminary plat for the Creek Bridge Phase 5 subdivision. Owner is GeoBrax Development LLC, location north of Creek Bridge, Phases 1, I and W, Richwood Road. Mr. Smith, if you please.
Yes, this is Creek Bridge Phase 5. This is the last remaining phase of this development. It's just kind of surrounded by the other phases to the west, south, and east. The property is zoned R1C, and the application of the preliminary plat does conform to the zoning of the property. There are no overlay districts that affect this property, and there are adequate utility services to be extended to serve this development. All the staff and third-party comments have been satisfied during our review process, and then staff does recommend approval of this Phase 5 of Creek Bridge.
Very good. Thank you, Mr. Smith. Is the applicant with us tonight?
Looks like there's
Yes,
one-
this is Eric Hodge with Roselle Engineering Company.
Hi, Eric. Did you have any comments other than what Mr. Smith just gave?
I know that the staff report was very well written. It covered the project. I'd be happy to answer any questions that the Plan and Zoning Commissioners might have.
Very good, sir. Stand by. We'll get right back to you. Let me go ahead and open up the public hearing. And is anyone here from the public wishing to speak on this at all, Megan?
No.
Okay. All right. Then I will close. I'm sorry.
Oh, yeah.
Let me clarify, there's no one in the room, but we do have a gentleman on Zoom.
Oh, I beg your pardon. That'd be Mr. Barton.
Yes.
No, I don't need to talk on this one.
Okay, so we'll close the public hearing on this and turn it over to the commission. Comments, questions? Seeing none, I would entertain a motion. When you make your motion, please give your reasoning for it, either based on the finding of facts or based on staff report. Just make sure that you include that in your motion, if you would, please. You will notice that in the staff report, I touch base on that real quick. This particular development does, in fact, as Cameron said, comply with the comp plan. When you make your motion, make sure that it's to forward a positive, a negative, or to table this moving forward. And again, with your reasoning for the recommendation. So if I could get a motion, I would appreciate it. Can't hear you, John.
I make a motion we approve based on recommendations of staff and the fact that it complies directly and completely with the comprehensive plan.
We have a motion on the floor to approve. Is there a second?
I second that motion.
We have a motion on the floor and a second. Any further discussion? Seeing none, roll call vote, please.
Dean Hutchinson,
Aye.
Jeff Garrison,
Aye.
John Dillon,
Aye,
Wim Oaks,
Aye.
and Pete Renfro.
Aye.
The ayes have it.
All right, thank you very much. Thank you, Mr. Hodge. Appreciate you being prepared for tonight.
Thank you for your time.
You betcha. That takes care of new business. Going to jump into discussion. First up, dark sky. Mr. Smith.
Yes, in your guys' packet, you'll see the latest draft of the dark sky ordinance. We went through and in the ordinance, the items that are highlighted are the differences from the last time you guys had seen the ordinance. We have incorporated all the comments that staff had received, along with some discussion or review from SIMCOG, the Southwest Missouri Council of Governments, who had reviewed the ordinance as well. In addition, we have added the majority of this revision is the bug rating information that we have been working on. interesting, something that I don't think we're really that aware of, but we learned a lot evaluating that, and trying to come up with a pretty reasonable way to incorporate that into the ordinance that's also understandable and not too cumbersome of development in Ozark. With that, we've had to forward this on to Ms. Callaway, our city attorney, for evaluation, and also RJ Flores has got a copy of this to evaluate and review as well. I believe RJ, if you're still on there, you're going to consider having maybe some supply houses or some of the contacts that you have evaluate the ordinance as well, just for some additional feedback to what we are proposing. Upon this, I think at this time, as far as the planning development department, we don't necessarily have anything else to add to this ordinance, but would be happy to address any comments, concerns, or additional information that the commission would like to see.
Comments, questions?
I have,
You're muted, John.
hello.
Gotcha.
I have one. Basically on the first page, why is the backlight uplight glare, the bug, why is that in yellow? Again, why is that highlighted?
The stuff that is highlighted in the ordinance are the revisions since the last time you guys saw the ordinance draft.
Understand.
Any other comments or questions? Now's the time. Okay. Cameron, last time did I just step on someone? Did someone want to say something? Okay. Cameron, last time you and I spoke, you were possibly going to be able to have this back to us in May as an ordinance. Is that still the timetable?
That is the plan. I'd like to get some feedback from Ms. Callaway and RJ, Mr. Flores as well. If there's any revisions, we'll incorporate those and bring those back to you with requesting the recommendation with those proposed changes, or the commission can further evaluate again. But yes, the anticipation is in May to bring back a proposed ordinance for recommendation.
Excellent. Finally, lots and lots of time on this one. I'm really appreciate the effort that staff has put forward on this subject matter. It's one of those that if you don't fully understand it, it's a little confusing and a little scary in some regards. But once you get down into the weeds and figure out exactly what it is that's going on, it's a really good program. So I'm really thankful that staff took this as seriously as they did, and I look forward to it passing. Yes, John.
Well, just like you, we've been thinking about this for decades. We think it'll put Ozark on the map, and once it's passed, I hope it will. I love the way it's going so far, what we've talked about up to this point. I hope that when it does pass, that there will be somebody standing by to write a story that we can somehow spread around. I mean, a really, really good press release that will go all around the state talking about the fact that we are becoming a dark sky community. I believe it'll be a really positive, have a huge effect on us. And I think we're maybe even the first city to do it in Missouri. I'm not sure.
Excellent. Okay. Anyone else? Any comments? All right. Again, we look forward to it coming to us next month if we're able to do that. Okay, here we go. Next up is Planning and Zoning Commission meetings.
Yes, I guess the discussion staff would just like some input as far as the continuation of Zoom and live meetings. The Board of Aldermen will be going back to in-person meetings at the council chambers, the second meeting in May. They are doing live meetings now at the OC, but in May they will be back at council chambers at the city of Ozark. We anticipate the planning and zoning going back to live meetings in May as well, but we are allowing for the opportunity if someone would like to Zoom in, by all means, we will provide those capabilities as well as to the commission and the public. Any way we can help get the public involved, we'll provide those opportunities. Also, we do appreciate having these streamed on YouTube for viewing as well as recording these meetings for purposes of following up to looking at the meeting notes after the meetings. So we'd like to get some feedback from the commission to get your all's thoughts. But staff does plan to have the live meeting back at the council chambers in May.
Any objection to that plan from anybody? Any thoughts on that? That option of being able to zoom in at the same time is a good one. Probably ought to maintain that for a while. Those that would prefer to zoom in or overcoming in and doing a face-to-face meeting, we should be able to give everyone an opportunity to continue to do that. I look forward to getting back face-to-face. It's been way, way too long. You know, these things are great. They worked out as well as could be expected in a very terrible time, but I think we lose a lot. I think we've talked about that. We lose the interaction with the people. People don't like to speak on this. So we don't get probably as much dialogue as that we would like. So I look forward to going back to face-to-face meetings in May. Anyone else have any comments on that?
Can't happen soon enough.
Man, a few words. I like it. Okay, good deal. Then we'll just wait to hear back from staff on that. Okay, next up is commission comments. Any of the commissioners have any comments that they'd care to share? Yes, Jeff.
This may be outside of our purview, but being in the building industry, this is kind of directed to you, Cameron. I know I run into some alternative products coming within the building industry due to costs skyrocketing on different products. If you guys ran into anybody wanting to put fiberglass rebar in flooring, walls, foundations to this point, and if so, what have you found? And that's just one example of some things coming in a price savings effort for building. And I ran into that. They're doing it in Bolivar, where I've got a cousin-in-law that's a concrete guy. It's just something that hit me, and I was just curious.
Nothing specifically to fiberglass bars, at least none in the applications or the plan submittals for permit have had those. We have seen as years ago as well, the fiber mesh reinforcement system. But no, I know we've heard about things as far as alternative materials, but nothing has really been proposed yet as far as a building permit application. But no, there has been discussions, but we actually have not seen actual application materials in place.
Any other commissioners have any comments or questions to staff or each other? Okay, you'll note. Yes, John. Yes, John.
Well, since Amanda's still here, it was a great presentation, Amanda. Thank you very much. And I have a comment. Whenever we get way out in the weeds emotionally with regard to zoning problems, where it starts to, you know, there people are protesting this and protesting that, and we begin to look at it, you know, in human ways. Why don't you just come in at that point and just read all of the precedent-setting cases that will ensure that the city will be sued if we vote the way the crowd wants us to. That would really help me from getting calls later in the week and, you know, my life threatened. I would appreciate it.
So what do you think about that, Amanda?
Happy to help.
It's hard. It's hard when you have 30 or 35 people in a room where a neighborhood is getting ready to be affected. They don't understand the process. They don't know we have a lane we have to stay in, and we can't get outside that lane. And you know, they're sitting around their coffee tables in their neighborhoods, and they're just getting themselves all excited, which I'm glad they do, because then they can work through their issues, and we want them to come forward. But as commissioners, as Amanda put in her presentation, you know, those are issues that we have to absorb as people, but we have to follow the law. We have to follow the guidance, and it takes us where we go. Yes, John.
Well, I know I was kidding there, but one of the things I learned were the histories of planning and zoning with regard to protests and things like that. I did not know that those 3 cases basically set all precedent with regard to zoning. And wouldn't it be, is there any way to get that out to the public with regard to what we are limited to do based on the legality of certain situations?
Well, this presentation was open to the public, and I doubt that very many people would be watching this with their free time, but I do provide educational material like this to whoever would ask, and I would be happy to provide it. And I have in the past when certain citizens request, information as to why zoning things are treated a certain way. And I would be happy to do that if anybody wanted it.
Good deal. Thank you. Anyone else?
On the same subject, I know I've heard some of the discussion about signs and how the free speech and signs have interacted, especially in historic buildings with murals. And then, so a city will approve murals being a type of signage, then it devolves into they can paint anything they want, including political signs and using even language maybe that's not appropriate. So when we have something like that come up, it would be wonderful if Amanda could just give us some case studies that shows that might be the repercussions of our decisions. And that's asking a lot of her, I know, but that'd be great.
I'd be happy to do that. I can provide some guidance related to the Reed case, which would be related to sign regulation, and it would probably be helpful in that regard.
Thank you.
You're welcome.
Anyone else? Okay, you'll notice with our Zoom tonight that someone is missing. I'm not sure everyone is aware of this or not, but after 25 plus years, Daryl McGuire has decided to ride off into the sunset and go hang out with his grandchildren. So he's no longer with us. I've asked Mayor Jackson to try to seek a replacement for us at his earliest convenience, so we can get back to being a full commission. If any of you, I don't know if I can speak for the Mayor Jackson, and I'll ask him in a moment. If any of you have any thoughts or suggestions that you might be able to just shoot him a name, he'll probably appreciate that. In the meantime, we'll just wait until we can get that next position filled. Lexi will be back in May. Mr. Jackson, I'm going to need him reappointed this month so he can come back into the fold in next month, if you would, please. Other than that, Mr. Flores, you have anything to add?
No, I was just gonna let you know, I do have a meeting with a couple suppliers about dark sky. And the main reason I think that me and Cameron were talking about is just making sure that there's nothing in there that we should include to make it easier for developers and builders to meet the requirements and give them a good avenue to where it doesn't seem cumbersome or expensive for them to adhere to it and get the result we want as a town. So I am working on that.
Good deal. Mayor Jackson.
Thank you. Pardon me. Yes, I will. I did communicate with the city clerk today. Alexi will be put on the agenda next week for the next meeting, the 3rd, to be reappointed and back on the commission. We are looking for other candidates. I am implementing back the application process. I'll be making a Facebook post within the next couple of days, asking for any interested parties to serve on any boards and commissions inside the city of Ozark to fill out that, so that we can go through and we can hopefully find the best suited person to fill some of these voids on various boards and commissions. As you know, it's very important to try to get people with a wide range of expertise to weigh in and help us make these great decisions. I do want to, again, thank all the members of the Planning and Zoning Commission for all your hard work and dedication to the city of Ozark over the past years. Daryl McGuire will be missed. I think he was one of the original commissioners and had set in term for the past couple of decades. And so that is a huge loss to the Planning and Zoning Commission, but I totally understand his reasons for stepping aside. Sometimes family gets neglected and you have to put them back in the primary position. So that being said, thank you again to the staff. Thank you again to the commission for all your hard work. Looking forward to meeting a couple of the individuals that I don't know that are on the commission. Hopefully we'll be back in person to person next month. And, we will work on honoring Mr. McGuire for his services to the city of Ozark. An invitation will be sent out to all the members of the commission that have served with him in the past. So with that being said, I'll sign off.
Oh, thank you, sir. Anyone else? Mr. Barton, did you have something you wanted to say?
No, thank you. Nope.
Okay, well, good deal.
Just watching.
Okay, I just wanted to make sure, give you an opportunity. Thank you for chiming in this evening. Okay, if there's no other, staff, anything from staff? Any comments from staff?
Yeah, I would add, you mentioned Mr. McGuire. we are working to get and I think it's ready today, a plaque that was created for Daryl, and I think it actually says something like 35 years. So quite a long-term commitment. So once we get that, then I guess, Mr. Mayor, Mr. Chairman, I'll discuss with you the appropriate way to get that presented to Mr. McGuire. So just to let you guys know.
Excellent, good deal. Okay, if there's nothing else, then I would entertain a motion to adjourn.
I'll make that motion.
We have a motion on the floor to adjourn. Do I have a second?
Second.
All in favor? Very good. Thank you all very much, and we'll see you face to face